delighted to introduce my colleague, Nathalie Bull. She's going to be speaking to you on relocation in Children Act cases. She'll be well known to many of you. She's got a wealth of experience in all areas of family law, often appearing in complex cases, multi-day fact finds, contested final hearings. She's referred to as being an extremely competent and highly skilled barrister in this year's Legal 500, and so I shall leave you in her capable hands.
Thank you very much, Esther, and good morning, everybody. Welcome to my talk on relocation in Children Act cases. So today we're going to be looking at how to apply for permission to relocate, what is the court's approach, what evidence is required, what steps should be made to enforce the order in other jurisdictions, and what are the prospects of appeal. Starting then with how to apply for permission to relocate the child internationally. A parent seeking to move internationally requires the written consent of all parties with parental responsibility, failing which the court's permission will be required. This can either be done through a specific issues order under Section 8 of the Children Act, or where a child arrangements order is in force, a freestanding application for a leave to remove order under Section 13 of the Children Act. In practical terms, there is no difference as to the test to apply. The welfare checklist will be applied, even though the welfare checklist is technically only necessary for Section 8 applications. It's worth noting that the removal of a child from England and Wales to Scotland doesn't require an application for permission to remove the child from the jurisdiction, since Scotland is part of the UK, and that was set out in Read T, a child from 2001. Permission to remove a child permanently from the jurisdiction shouldn't be had by lay justices, but should be transferred upwards for determination by a district judge, circuit judge, or high court judge, depending on the complexity and difficulty of the decision. Section 13 of the Children Act sets out that where a child arrangements order is in force, a parent seeking to move internationally requires the written consent of all parties with parental responsibility, failing which the court's permission will be required. I've set that section out on this slide for you. Relocation within the UK can present problems because while the primary carer might not have an obligation to apply under Section 13 of the Children Act, the resident parent may still have to defeat an application for a prohibited steps order under Section 8, or for the imposition of a condition to the child arrangements order under Section 11(7), such as if the child arrangements order specifies the geographical area in which the child must live. The resident parent may need to apply to vary an existing child arrangement order if they would be unable to comply with the order after the move. For example, midweek contact can become problematic. The resident parent may need to apply for a specific issues order if they would need to move the child's school to a local school if the other parent won't agree. Because welfare is the governing principle in any internal relocation case, there is no reason to differentiate between internal and external relocation cases. Moving on to the court's approach, whether the application for permanent overseas relocation is configured under Section 8 or Section 13 of the Children Act, the most recent and authoritative appellate decision on the approach to such applications is set out in Re F, and that's 2015. The court should concentrate not on assumptions and preconceptions, but on the statutory welfare question which is before it. As per L and F, Relocation, Second Appeal 2018, the Court of Appeal confirmed that selective or partial legal citation from the well-known case of Pain and Pain from 2001, without any wider legal analysis, is likely to be regarded as an error of law. In particular, a judgment that not only focuses solely on pain, but also compounds that error by only referring to the 4-point discipline set out by Lord Justice Thorpe in Pain, is likely to be wholly wrong. And a step as significant as the relocation of a child to a foreign jurisdiction, where the fundamental interference between one parent and a child is envisaged, requires that the parents' plans be scrutinised and evaluated by reference to the proportionality of the same. Lord Justice Voss in Re C, Internal Relocation, and that's 2015, stated, in cases concerning either external or internal relocation, the only test that the court applies is the paramount principle as to the welfare of the child. As per Re F, the framework is set out to be the only authentic principle is the paramount welfare of the child. Heightened scrutiny is required of the proposals. The welfare checklist is relevant. The case of pain may be misleading unless viewed in its proper context. And you must carry out a holistic and non-linear comparative evaluation of the plans. Further, the rights of the child to maintain personal relations and direct contact with both parents on a regular basis must be considered, and the child's Article 8 right will take priority over the parents. The balancing exercise to be carried out in each and every factor relating to the child's welfare should be weighed to determine which of a range of options best met the requirement to afford paramount consideration to the child's welfare. Lord Justice Ryder proposed that a balance sheet approach may be helpful with the pros and cons of each proposition. This approach can assist in making sure that all relevant considerations are taken into account, though it should be noted, as the President has emphasised, that such a balance sheet is a tool to help with making an assessment, and it's not a substitute for a reasoned judgment. This is particularly true since a balance sheet will usually give little, if any, indication of the weight which individual factors should have, with the consequent risk that it may erroneously appear that all elements of the table have equal value. In Re C, Justice Williams considered the overall holistic evaluation to be key, with weight to be afforded to the child's right to maintain contact with the left-behind parent and their rights to a stable and secure family life with their primary carer. As per Re C, 2015, international relocation cases, reliance on the pain guidance without a broader legal analysis of welfare may amount to an error of law, which is likely to result in a successful appeal. And that's paragraph 27 of the Re C case. Again, as per Re C, there are limitations in the pain reasoning, including its lack of adequate focus on the views of the child concerned and its gender-biased presumptions about stereotypical parenting roles. And that's paragraph 18 of Re C. The pain guidance appears a linear approach rather than a holistic approach, considering all options. While it's not necessary for the court to refer to the case of pain, for completeness and for convenience, I've set out the pain guidance here. But it should be noted to be warned that the courts have made it clear that judges are not to be straitjacketed, and each case turns on its own merit, with the child's welfare as the primary focus. In Re C, International Relocation 2017, the Court of Appeal confirmed the proper approach to the whole issue of relocation, which can be summarised as follows. There was no difference in the basic approach as between external relocation and internal relocation. The decision in either case hinged ultimately on the welfare of the child. The wishes, feelings, and interests of the parents and the likely impact of the decision on each of them were of greater importance, but in the context of evaluating and determining the welfare of the child. In either type of relocation case, external or internal, a judge was likely to find helpful some or all of the considerations referred to in Payne, but not as a prescriptive blueprint, rather and merely as a checklist of the sort of factors that would or might need to be weighed in the balance when determining which decisions would be better to serve the welfare of the child. The relevant passage in Re C is here for your reference on this slide, which was summarised in the previous slide. We are all very familiar with the welfare checklist, but it's here on this slide set out as it should be applied in relocation cases, and the child's wishes and feelings are of course a factor in that process. However, even with older children, their wishes and feelings are only ever one of the factors to be considered in arriving at what is in their best interests. Where there is more than one child involved, the court must consider separately the interests of each child in light of their ages, stages of development, and the nature of their needs. And that's as per Re S from 2011. The best way of evidencing ascertainable wishes and feelings is generally through an independent CAFCAS report to consider how the existing contact may be disrupted by relocation. However, in some cases, a report will not be considered necessary, and ordering a report will not always be helpful to the court in reaching its decision. It is a matter for the judge's discretion. As with other areas, the judge is entitled to depart from the recommendations of the CAFCAS officer where the report is not balanced. The judge has to look at the case in the round. In cases where a child's caregiver has already gone to live abroad with the child, the guidance is that it would be sensible for the child to be separately represented, and that's as per Re B 2017. What evidence is required to increase the applicant's prospects of success in a relocation application? Well, the applicant needs as much detailed evidence as possible. The witness statement must explain the applicant's genuine motivation to relocate, including the reasons and background. They need a detailed plan with property particulars of where they intend to move to. With regards to schools or nurseries, they should have visited a couple of the schools in the new area. All parties with parental responsibility should be involved in the choice and should be given the opportunity to look at schools in the proposed new area. There should be a letter from the school or schools with an offer of a place for the children. There should be the Ofsted reports and even details of the distance and journey time from the new home to the new school. Contact proposals will be essential. This should include the practicalities of the travel and handover locations and arrangements, including the mode of transport, such as whether it be train, flights, or car. The details of how the child could continue their current friendships, which may be very important to the child. Social network details, including friends and family, toddler and playgroups and children's centres to show support networks. Extracurricular activities for the children, especially if they have a particular interest in, for example, dance or swimming, should be provided. The plan for work for the parent, including any job offers or a plan to set up a business or work from home, should be provided. And there should be medical information, including the GP or dentist surgeries. And if the child has any specific medical needs, It would help to show local availability for that. It is not good enough for a witness statement to say that after the court determines the application, the applicant will then plan the move and look into homes and schools. The court is required to scrutinise the plans, and with such bare information, it is very difficult to do so. What about the respondent's witness statement? Well, a respondent will inevitably look for evidence or signs of the applicant seeking to disrupt the child's relationship with the respondent, and then run the argument that it's not a genuine wish to relocate, but rather an intention to cut the respondent out of the child's life. The respondent's statement must focus on the child's welfare rather than seeking to exert control over the applicant. The respondent's statement must set out their plan for the child, perhaps a change of living arrangements for the child to live with the respondent. The respondent will need evidence in support of their plan. For example, it may still involve a change of schools to be closer to the respondent's home. Will the respondent work be flexible enough to allow for drop-offs and collection from school? Is there a letter from the employer confirming that? What child arrangements are proposed by the respondent if the applicant still relocates without the child? And what are the practicalities, including travel, handovers, costs of that arrangement? The court will need to scrutinise the respondent's plan equally as it would scrutinise the applicant's plan. The court must also give regard to the extent or absence of any reciprocal enforcement regime in the foreign country, and the court must assess carefully the risk of breach of any contact arrangements and the magnitude of any breach. It is for the court to achieve what security it can for the child by building in all practical safeguards to the order. As per Section 25 of the Family Law Act, certain orders, including Section 8 orders made within one part of the UK, are recognised in all other parts of the UK, but must be registered under Section 27 of the Family Law Act to be enforceable. Out of the jurisdiction, it may be necessary to apply for a mirror order after seeking legal expertise from that particular country. Orders made in any country which is party to the Hague or European conventions are recognised and then enforceable in any other convention country. Non-convention countries may refuse to make inconsistent orders. It may be that the applicant is willing to offer an undertaking to register the order or apply for a mirror order, and or the court, of course, can direct that to be done. Appeals. In the case of NJ and OV, Mostyn said, "It is my opinion that outside the sphere of state intervention for the purposes of child protection, the hardest decision that a judge ever has to make in the field of family law, or for that matter, in any field, is a relocation decision. The choices are starkly binary. One or other parent will lose and will be bitterly disappointed. There is no scope for finding some comfortable middle ground." As per REC, Permission to Relocate 2014, the more finely balanced any decision may be regarding the future welfare of a child, the less likely it is that any consequent appeal will succeed against the judge's decision to choose one viable option against another. Compare that with RE Children 2017, which is an example of a finely balanced case where the Court of Appeal held that a clear welfare assessment was absent, and the judgment fell a long way short of adequately explaining the judge's analysis of the needs of 3 young children. In my own practice, I've seen a range of outcomes. As a recent example, I successfully opposed a mother's application to move from Worcester to Birmingham, a relatively short distance apart of approximately 30 miles, despite the mother in that case having put a great deal of thought and time into considering all the relevant evidence, and she had arguable proposals for the existing shared care arrangement to continue. It turned on the welfare interests of the children, and the court considered that there would be too much travel time on an almost daily basis for the children going back and forth. That case can be compared and contrasted with another recent case where I successfully secured a specific issues order for a mother to move the child from the Birmingham area to a remote part of Scotland, which had the effect of significantly reducing the father's time with the child, limited to school holidays only. The court concluded the child's welfare interests were in favour of relocating with the mother to join her stepfather and half-siblings who had already relocated to Scotland. The child would have been emotionally damaged if she was left behind, and left behind with her father. And despite her father running a change of living arrangements argument, when scrutinising his plans, he really wasn't in a practical position to care for his daughter. These contrasting cases show that each case turns on its own specific facts, and both of those examples had an outcome which very much focused on the child's welfare interests, because of course welfare is paramount. Well, I hope my talk was of some interest to you. Do feel free to send any questions to me on the Q&A facility, and I'll do my best to answer them either in writing or at the end of the seminar. May I now introduce Esther Lieu, who was called in 2011. Her practice comprises of all areas of private family law, with a particular focus on financial remedies and private law children proceedings. Over to you, Esther.
Thank you very much, Nathalie. You will all, countless of times, have had a client who comes to you for advice on their divorce, in particular on their finances, and they start telling you about all the awful things that their partner has done, or their ex-partner. How they never unloaded the dishwasher, they always got home late, they never helped with the children, perhaps they gambled away the inheritance, and they say, surely they shouldn't get anything. And you say to them, well, the court is no longer a court of morals. The court is not going to want to litigate your breakup. Yes, there is reference to conduct in the statute, and there is a conduct box in your Form E, but actually it's best to forget about it. And today we're going to look at whether that has changed. So, like all good lawyers, if we start by looking at the statute, section 25 of the Matrimonial Causes Act, we know that in considering whether to exercise its powers, the court has a duty to have regard to all the circumstances of the case, and in exercising its powers, it shall have regard to, amongst other factors, the conduct of each of the parties, if that conduct is such that it would, in the opinion of the court, be inequitable to disregard it. In the relatively recent case of OG and AG, Mr. Justice Mostyn identifies 4 scenarios in which he says conduct may be considered in financial remedy cases: gross and obvious misconduct, the ad-bac jurisdiction, litigation misconduct, and fourthly, drawing inferences as to the existence of assets from a party's conduct. And it is the first category, the personal misconduct, which we're going to look at. Personal misconduct, as we know from the statute, it must be such that the court would, if found, consider it to be inequitable to disregard. What does that mean? It means, as per Lord Denning, that it should be obvious and gross. The phrase the gasp factor has also been used, and this was then approved by the Supreme Court, or the House of Lords, in Miller Macfarlane, who said that this approach was not only right, but it was also the only practicable one. It's simply not been possible for the court, save in the most obvious and gross cases, to pick over who was more to blame. So not only must conduct be gross and obvious, but, says Mr. Justice Mostyn, there must also be a financial impact of the party's conduct, saying that conduct should be taken into account not only where it is inequitable to disregard, but only where its impact is financially measurable. Now, there are rare instances, or there were prior to that case, rare instances where conduct had been reflected in the absence of an identified financial impact. And as we shall see, perhaps there may be more to come. Now, in that same case, AG and OG, Mr. Justice Mostyn identifies that economic abuse is a form of personal misconduct. And it is helpful here. You'll note that I'm providing the quotes in full. I'm not reading them all out, but you will have the presentations available after this to go back to. Going back to economic abuse, I think it's helpful just to take a step back, looking at the Domestic Abuse Act of 2021 that came into force of October 2021, where economic abuse is defined as a form of domestic abuse, and it is then further defined as being any behaviour that has a substantial adverse effect on B's ability to acquire, use or maintain money or other property, or to obtain goods or services. Now, in practical terms, economic abuse may look like some of the following: limiting or controlling someone's access to money, controlling the family finances, not allowing a spouse to work, appropriating their wages, perhaps making the partner liable for debts, coercing them to take out credit, or refusing to pay bills and thereby putting the family into debt. I mean, to add to that, economic abuse may be present within proceedings. You may have a respondent who deliberately prolongs proceedings, they refuse to engage, they make unnecessary applications, or in order to exhaust your client's funds. But those latter examples are perhaps more appropriately addressed at the cost stage. The case of DP and EP, this was decided by Hon. Judge Reardon, sitting in the CFC in January of this year. It appears to be the first reported case where economic abuse has been found to amount to conduct within the meaning of section 25(2)(g). And we're going to spend a little bit of time looking at this case. The wife was 49, the husband was 59, a marriage of 24 years, the children were all adults and financially independent. The capital was just under 1.5 million, and on the face of it, there would have been no reason to depart from an equal division of capital. The husband, interestingly, was functionally illiterate. He had viewed the parties' financial resources as being fully mingled, and he assumed that the wife was managing their joint assets for the benefit of them both. The wife was described as having considerable professional experience in property sales and investment, and that distinction is relevant. The husband argued that the wife had defrauded him by dissipating or diverting assets, and he ran three arguments. He ran an add-back case, namely that there were certain funds which the husband said the wife had either recklessly or deliberately dissipated from the parties' resources, which should be added back into her side of the asset schedule. He ran a negative inference case, saying that the court could infer that it was likely, more likely than not, that the wife had undisclosed assets on account of her conduct. And thirdly, he ran a conduct case, saying that her conduct in and of itself was something that would be inequitable to disregard, her conduct amounting to economic abuse. He sought 63% of the total assets. The wife denied all the allegations. She raised a few of her own. She didn't pursue them, but in any event, she offered roughly an equal division of capital. She would retain some of her own debts, amounting to a 45-55 split in the husband's favour. The court heard evidence on 5 sample allegations that the husband put forward, examples of the wife's conduct, he said. The first was in respect of a flat that she had purchased in 2007 or 2008 with a third party, Mr. F. She did not tell the husband about the purchase at the time, and he did not discover the existence of that property until 2018. The wife said that initially she'd been managing it for a landlord. She then accepted that she had purchased it in 2007 or 2008, and she accepted that she had transferred her share to Mr. F in 2018 for just over £82,000, but then sought to argue that the purchase had been from redundancy funds and as such was non-matrimonial. The court rejected her argument that it was non-matrimonial and concluded, satisfied both that the husband did not expect the wife to engage in a transaction as significant as a property purchase without informing him, and that the wife knew that the husband would view this as a breach of trust. The second allegation was in respect of ex-development investment. A few months after receiving the £82,000 from Mr. F, the wife paid £60,000 purportedly to a property development company. There was evidence heard as to whether this was a genuine opportunity. In any event, there was no return on it. The wife says that the funds were lost. The husband says that they were put out of his reach or that the wife was reckless. The court said, in my view, it is inherently improbable that the wife threw away these funds, again, given her professional expertise, and the more likely explanation being that she removed the sum of £60,000 from the husband in a deliberate attempt to put them out of his reach. The third allegation in respect of a joint bank account that had originally held funds of £350,000 that had been received from the sale of a property that the husband had inherited. He accepted that some of the money had gone towards the purchase of two other properties, but expected there to be more than £30,000 at the time of separation. And he pointed in particular to one transaction of £30,000, for which he could not account. The court accepted, again, the husband's case that this amounted to a deliberate diversion of funds by the wife, where in circumstances if the husband had known, he would not have consented. He did not, however, actively seek an add back of that £30,000, perhaps bearing in mind the historical nature of it. The fourth allegation was in respect of the rental income from a jointly owned property that the parties held in Dubai. It was tenanted from 2012 through to separation. The husband assumed, as that property was mortgage-free, that the rental income would be accruing in a joint account in Dubai. It turns out that no rent was paid into that account, and in fact, seemingly, it was not paid into the wife's account either. The wife's case eventually was that the funds had been paid to her sister, and she offered to pay the husband 50% of any funds that she was able to recover. The court found that the wife, possibly with the assistance of her sister, had deliberately diverted the funds with the specific intention to remove them from the husband's reach. And using some conservative figures of anticipated income and associated expenses, the court found that the missing rental profit probably amounted to £100,000. Finally, the last allegation was the wife's attempt to sell flat 2. This was a property owned by both parties, purchased in 2008, that the husband said the wife attempted to sell in 2014 or 15 without his consent. Fortunately, the sale never went ahead, the conveyancing solicitors being diligent and not wishing to proceed without the husband completing the Know Your Client procedures. The court noted that many of the emails to the solicitors were sent from the husband's account. The wife accepted sending them, saying that it was with the husband's consent. The husband said he had no knowledge of those emails, and the court again preferred his evidence. The court concluded, I'm in no doubt that this was a deliberate effort by the wife to sell a jointly held property without the husband's knowledge, and that she was hoping to retain the proceeds and use them for her own benefit. So, says the judge, looking overall at the wife's conduct, it falls within the definition of economic abuse, and it had a substantial adverse effect on the husband's ability to access and use the finances. Importantly, the fact that he was unaware of the wife's behaviour at the time and it was not directly impacted by it during the course of the marriage was not relevant, In fact, it only made his subsequent discovery of it more shocking. Having made her findings, the judge then turns to the computation exercise, and she includes back onto the wife's side of the ES2, the £60,000 from the investment and £25,000 from the missing rent that she considered the sister was probably holding and was likely to be available to the wife. She added back a further £75,000, that being the balance from the missing rent, by way of add back, acknowledging that it may in fact perhaps no longer be available to the wife. But in total, £160,000 was added back to the wife's side of the asset schedule. Having completed the computation stage, the judge then moved on to the distributive stage. And I pause here just briefly to note that there is very little clear guidance, consistent guidance, as to how, if conduct is found, it should, if at all, be reflected in any financial award. Previous authorities proposing that it could perhaps drive the judge to the very top of the discretionary bracket applicable in that case, perhaps be a magnifying factor when considering a party's position under the other subsections, or perhaps it should mean that one party's needs are prioritised over those of the other, provided that that party is not reduced to a real predicament of real need. Returning to DP and EP, the judge considered all the section 25 subsection 2 factors before then turning to conduct. She noted that the findings in respect of the development investment and the missing rent had already been reflected in the adjusted ES2 and should therefore play no further part in the distributive exercise, as that could result in double counting. So the question was whether the wife's conduct beyond those two instances be reflected in the award, even if there was no further direct financial impact. To which the answer was yes. The judge considered that too narrow an interpretation of section 25(2)(g) would render the provision nugatory, saying that there must be scope, or some scope, for conduct which has had consequences to be reflected in the ultimate division of assets, even where those consequences are not financially measurable. She decided, therefore, that the wife's needs should be met, but with needs being elastic at a more modest level than they would have been had those findings not been made. She awarded the husband 53% of the total assets and 47% to the wife, noting, of course, that of that sum of 708,160 had been returned to the court. The husband applied for costs, unsurprisingly, on account of the wife's litigation misconduct, and the court found that had the wife come clean about the transactions, the proceedings would have been considerably shorter. They ordered her to pay £40,000, being satisfied that it would not affect her ability to meet her needs. Of course, that case was determined at the CFC. There's been no higher authority yet on those points, but it is early days yet. Before I move on to coercive and controlling behaviour, a quick look at SS and RS before Mr. Justice Cohen. Earlier this year, this was an application by the husband for, amongst other things, compensation on account of the wife's failure, he said, to release him from the mortgage in a speedy manner, in line with the undertaking she had given at the conclusion of financial proceedings, saying that he had suffered economic abuse. He did, however, have to accept that he had not ever paid anything towards the mortgage and that the wife had, in any event, indemnified him. Moreover, by the time of the hearing, she had secured his release from that mortgage. The court considered that his claim was misconceived and he was ordered to pay her costs, particularly on account of not withdrawing his application when she was able to secure his release. Having therefore considered economic abuse as a form of personal misconduct, looking at coercive and controlling behaviour, and returning to the Domestic Abuse Act 2021, where we see that it is provided for at subsection 3C, again, as a form of domestic abuse. It is not further defined in the Domestic Abuse Act, and so I have included the provisions in PD 12J, noting, of course, that they are not directly applicable to financial remedy cases, but in my view, I see no reason as to why the definitions provided therein are not going to be transferable to financial remedy cases. The case of Traherne and Lim, you've probably all come across it or heard of it. It provoked some excitement when it was handed down. It concerned the validity of postnuptial marital agreement that was entered into by the parties, the wife's case being that she was subjected to coercive and controlling behaviour by the husband at the time that she entered into it, with the consequence being that she was unable to freely enter into the PNA and that it should be afforded no effect. The court was asked to consider whether coercive and controlling behaviour, if proved, falls within the pre-existing Edgar criteria or whether it represents a new category of circumstances. The Edgar criteria being, as we know from the judgment of Lord Justice Omrod, being including but not limited to undue pressure by one side or the exploitation of a dominant position to secure an unreasonable advantage, as was approved by the Supreme Court in the case of Redmach and Granatino in 2010. Mr. Justice Cohen continued that, in his view, coercive and controlling behaviour would plainly be an example of undue pressure, exploitation of a dominant position, or of relevant conduct, and it would form part of all the circumstances as they are affecting two parties in the complex relationship of a marriage. Now, as I say, there was a degree of excitement when this judgment was handed down. However, in my view, or not just my view, as a fact, the observations are really limited to that only, because in respect of the wife's allegations of coercive and controlling behaviour, she did not succeed in seeking those findings. The court found that the husband's behaviour was at points he would lose his temper, but that his behaviour could not objectively be described as coercive or controlling, or that it led the wife into entering to the PNA. And indeed, the PNA was in fact set aside on the basis that it did not meet her needs, and it would be unfair to hold her to that agreement. So we don't know what bearing, if any findings of coercive and controlling behaviour would have had on the court's approach to the enforceability of the PNA. We don't know whether any such findings would have put her in a better position overall. So when considering costs, orders were made against the husband as the wife was not held to the PNA. However, the wife did retain a liability of £60,000 to £70,000 of costs, which Mr. Justice Cohen considered to be appropriate, given both her excessive costs, but also her approach to litigation, which he considered was misconceived, given that the conduct argument was unsuccessful, it took 2 days and added nothing. That then leads us to a case, again, a very recent case of MN and AN, the case of how conduct should not be run. This came before Mr. Justice Moore last month and was again an application by the husband to the wife to show cause why she should not be held to the terms of a prenup signed in 2005. Now, the wife had completed the conduct box in Form E, asserting that the husband had behaved in a coercive and controlling manner. She then decided not to run a conduct argument. This was confirmed within her Section 25 statement. Nevertheless, her statement then proceeded to raise a variety of allegations against the husband, essentially saying that his treatment of her had made her seriously doubt her own intellectual abilities, such that she felt entirely dependent on the husband. Mr. Justice Moore considered that, with the possible exception of one allegation, there was not a shred of evidence of coercive control in this case. Her counsel then suggested that the husband's behaviour be relied on not as conduct within Section 25(2)(g), but as a circumstance of the case. This was met with short shrift by Mr. Justice Moore, who said that relying on it as a circumstance of the case was roundly condemned in Miller Macfarlane and should never reappear in this type of litigation. His reference to Miller Macfarlane being to the words of Lord Nichols, who said that in approaching the approach of including conduct within all the circumstances of the case was erroneous, again highlighting the presumption that in the vast majority of cases, parties' behaviour will have little to no bearing on the outcome. This then brings us back to your client sitting before you and some practicalities, some things to consider. Firstly, the statute, of course, remains unaltered. Conduct must be such that it would be inequitable for the court to disregard, and it remains at the discretion of the court how much, if any, weight should be afforded to it. And the threshold as established by the long line of authorities again remains as high as it always has. Nothing has been said or done to lower it. So some things to consider when you are talking to your client is, will running a conduct argument in fact make any difference? Again, refer you to the case of Traherne and Lim, where the P&A was set aside on alternate grounds and the conduct argument was seen to be somewhat of a waste of time. Is there enough money? That's probably, in fact, the first question that you would want to look at. If this is a needs case, then the court is unlikely to make any order that puts a party in a real predicament of need. Add back is, of course, all well and good, but in adding back, the court still has to nevertheless remind itself that those are funds which are not actually available to meet a party's needs. There are evidential difficulties in respect of coercive and controlling behaviour. Those of us who practice in private law and have perhaps run coercive controlling arguments within private law proceedings know evidentially quite how difficult it is to prove the insidious nature, invariably, of the respondent's behaviour. Means that there is often very little contemporaneous or corroborative evidence, and that, of course, then makes it far more difficult both for the party and for the court. Similarly, with economic abuse, again, when one looks, for example, at the case of DP and EP, it is at times quite subtle. There is a huge amount of forensic analysis required in order to be able to establish economic abuse to the requisite standard, and the question therefore must be posed not only as to whether that evidence is going to become or be available, also whether it is proportionate to pursue it. The costs involved are likely to be significant. There's going to be the gathering of evidence, the preparation of statements, there will be pre-trial reviews, and invariably multi-day final hearings. So again, it does need to be proportionate. And finally, there is the risk of costs. Notwithstanding the fact that the starting point within financial remedy proceedings is that there is no order for costs, the court, of course, does have a discretion to make a costs order, as we have seen in the case of DP and EP, in the case of AG and OG, if the court considers that it was an unreasonable argument to pursue, that there was litigation misconduct, then a costs order may be made against your client. And so those are some of the things to consider. On that note, we have a little bit of time left for questions. So I will hand you back to my colleague, Nathalie. She will respond to some of the questions that have been raised on her topic whilst I review the questions that have come in on mine. Thank you.
Well, thank you very much, Esther. That was a brilliant talk, fascinating. So we had lots of questions. Thank you very much, everybody. One question seems to repeat quite a lot, which I'll read out, where a parent with care relocates a child without agreement. Does this justify filing an application on behalf of the other parent without mediation to avoid delay, which might strengthen a status quo argument? Well, it's strongly inadvisable to consider an international relocation without written agreement from all those with parental responsibility or permission of the court. The reason is that interference with a parent's rights of custody is child abduction. The consequences of parental child abduction can include orders that the child can be summarily returned, or even criminal charges. An application should be made in the High Court for the return of the child under the Child Abduction and Custody Act 1985. Section 6 asks if you have used family mediation to attend to agree the arrangements, and if not, to explain why. The answer is the urgency of the situation. So that relates to international relocation. If the parents are already taken the child internationally, that's what you would do. And so no, you wouldn't need to do the family mediation there, because it's an urgent return of the child. If it's internal relocation, it's a different matter. If there is no order preventing such internal relocation, unless the application is urgent due to the child being at risk of harm, then it's likely that you or the parent would have to undergo mediation first, if it's not considered to be urgent due to the lack of safeguarding issues. So that's the approach there. I think we're going to take it in turns, Esther, are we? Do you want to go ahead with answering one of your questions, Esther?
Yes, I shall. I have had a question that has come in asking how one would resist claims of economic abuse or coercive and controlling behaviour. Good question, of course. It's always going to be for one side or the other. My answer probably really takes us back to the presentation, and it's to say to identify the criteria or the factors that need to be met in order for the application to succeed, and therefore to challenge it at each of those points. So if you're in correspondence with the other side, perhaps to be undermining the evidence that they are seeking to rely on, suggesting that it is deficient, that it is not going to meet the evidential threshold, or indeed the sort of threshold of it being obvious and gross that is established. Questioning whether there is a financial impact of the conduct in itself. I know the case of DP and EP considered that an additional reward could be made in the absence of there being a direct financial impact, but that was of course in the context where there had been financial impact arising from some of the wife's additional behaviour. So if there is no identifiable financial impact at all, that may give you some grounds to resist those arguments. Again, this is the point about the finances, really asking, is there enough money to go round, pointing out to the other side that if it is a needs-based case, or if it's going to be an ad-back case, that it's going to leave the party, even if they were to succeed, in a situation of real need, which the court would not want to do, and threaten them with costs. I'm not saying to take an unnecessarily litigious approach, but it should be a real concern for any solicitor or any party wanting to run a conduct argument, and you would be well entitled, therefore, to raise that at any point in your correspondence, that is something they need to be mindful of. So, as I say, I would look at what one needs to run a successful case and undermine it at each level. Passing back to you, Nathalie, if you've got any others.
Thank you, Esther. One question, if the CAFCAS safeguarding letter says there's no safeguarding concerns and no further role for CAFCAS, is there an alternative to a Section 7 report? Well, good question. And a potential alternative is to apply under Part 25 of the Family Procedure Rules for an ISW report, Independent Social Worker report, which would, of course, have to meet the test of necessity. ISW reports can be potentially better quality reports, but there is a risk, of course, involved, as it could recommend either for or against your client's position. The benefit is that if the parties agree to follow the report recommendation, the matter could be resolved by agreement rather than going to final hearing, potentially therefore saving costs and time. Back over to you, Esther.
Thank you. I've got time for one more, and that is whether an FDR can be effective, or how effective can an FDR be in circumstances where conduct is run? That's an interesting question, because of course, on the one hand, if conduct forms a central tenet to a party's case, then it is somewhat of an artifice to put it to one side during the course of an FDR. And equally, it could polarise parties' positions if that is a very central part to a party's position at the outset of proceedings or within an FDR, and make negotiations somewhat difficult. That said, we know from AG and AG again that there is a duty on both parties to continually negotiate and to negotiate reasonably throughout proceedings. And so I don't see, certainly from my experience, that there would be any scope for the FDR to be bypassed on account of conduct arguments. Clearly the courts, the judge at FDR would not be able to make any findings in respect of that conduct, but that in itself does not allow the parties to bypass it, and they must nevertheless approach the FDR with a genuine attempt, a genuine desire to settle. It may be that it won't, but if there is any suggestion that they are taking an unreasonable stance or not making use of all available opportunities to settle, then they could be penalised in costs, even if at the final outcome, as was in the case of AG and AG, an award is made in their favour, the court will nevertheless look at their litigation conduct throughout the proceedings. So whether an FDR will be effective or not is perhaps dependent on the facts, but should you nevertheless engage with it? Yes. And that, I think, brings us neatly to midday. I will just again hand you back to Nathalie to conclude matters.
Thank you, Esther. Well, thank you very much to everybody for joining us today. The next family law brunch will be on Thursday, the 25th of May, again at 11 o'clock. I think the registration link is in the chat box. Thank you, Delphine. So feel free to click on that. Alternatively, I'm sure it will be sent to you in due course. We hope you can join us then, and we hope you have a lovely day today. Thank you very much. Goodbye.